Hey, Arianne, we'll probably just give it a little more time for people to come in.
Sure, no problem. And I'll be able to share my my screen.
Yes, you will.
Great. Oh yes, I'll get that set up then.
Well, Ariane, I would say you can get started whenever you're ready to.
Okay, so it's all right. I
Yeah,
will be
yeah, we'll
happy
just
to.
let more people in as they come.
Okay, great. So let me share my screen. All right, well, hello, everybody. Very nice to see you. I am Arianne O'Donnell. I am the attorney partner for KW, and my office is in Stamford. I'm across from the training room, and I have been working with you all since 2013. I just looked at that recently. I was like, wow, time flies. And I'm very excited and happy to, see a lot of people I know, but meet so many new people. I'm happy to answer any real estate questions you may have. And I will go ahead and start the presentation so we can get to all these different lessons. And if you have any questions during any particular one I'm talking about, please feel free to ask me any questions. And we'll also have time at the end. I can answer any questions then, as well as hear what stories you may have. So as I'm saying, after 20 plus years of real estate closings, I am still learning. It is amazing how something will still come up that's just like, wow. and I've talked to a lot of other attorneys, brokers, my title company, and there were a lot of stories that have come out. So I picked a few to discuss, and we'll start with the first one. So the first one is appraisal value. The appraisal came in lower than the purchase price, and the clients had a mortgage contingency. So it used to be that if property didn't appraise for what the purchase price was, then the buyer would be denied their mortgage, and therefore the buyer would have the opportunity to withdraw under the mortgage contingency. However, there was a special program at the bank that qualified them still. So there was no way to get a denial letter because they still qualified with having enough money to put in on their own. So the situation happened where they continued on with the purchase and had to make up the difference with the money. So the lesson learned is to add an appraisal contingency in addition to the mortgage contingency in the offer and contracts. But I do have a 2022 caveat because, and I talked about this recently on the Thursday morning call, that's a little changed because right now, most sellers will not accept appraisal contingencies as part of their offer. But in the future, if things stabilize with the seller's market part, you would want to add that appraisal contingency. But right now, the closing numbers are not up to date. Recordings are not happening showing what the sales are. And that's what the appraisers have to go by, whatever's in the last 90 days. So there were three options to handle it. One is to that the buyer just accepts whatever amount of money they need to pay, that they negotiate something in the middle, or what I've seen a lot of you doing now is putting in a cap saying that the buyer will pay up to X amount, and if it appraises more than that, then forget it, the buyer can back out. So there are some options to handle that now. But in the future, down the road, if you can add an appraisal contingency, that is worth it. That is good to do for the previous lesson. So that's my lien on title. Are you sure? So title search was ordered. This is way back when we did where title searches weren't ordered until the buyer's mortgage approval came in, because the buyer didn't want to spend the money on the title search until they knew for sure that they were all set with their mortgage. Then title search came in to show that there were two mortgages and a U.S. tax lien, and the seller was unaware of the tax lien, which then put the property underwater. So it ended up that the buyer could not continue with the sale that they wanted to purchase late in the game, and they were the whole deal fell apart because the seller was unable to give good title to the property. So the lesson learned, we order now the title search after the contracts are signed, not after the approval. So it is an expense the buyer is going to have to pay if the deal still falls through, but it is something that is very important to get a good idea ahead of time of what the situation is with the property. Because then we don't have any time delays or issues that can happen and cost more. In this case, the seller was required to pay for the non-refundable expenses, which they did not do voluntarily, and the buyer had to sue them in small claims court to get that. So it was not a good situation all around. So, but it's your house. Lesson. So the buyer had a mortgage contingency, but there were no specifics on the type of loan. And the buyer had applied for an FHA loan. Now, you may know that the FHA loan has way more requirements and conditions than a regular conventional loan. And one of the requirements that often happens is if the FHA appraiser sees something in the property that needs fixing or doesn't comply with safety, they can require it to be fixed before they will sign off on the appraisal and before you can get the mortgage, the buyer can get the mortgage. So the FHA lender came back with required repairs to the property and the seller refused to do it. And the buyer can't get the mortgage until the repairs are done. So they ended up paying for those repairs to be done and improve the seller's house before they were even the owner. So it's not the best situation, but it's always good to make sure to add what type of loan it is. And I mention this more so for the standard real estate contracts that are the fill-in contracts, that if it's a specific type of loan, make sure to note it in there so it protects your client. That was the solution. I jumped ahead. So, make sure to add if it's an FHA, a 203K loan, which is a rehab loan that allows the buyer to use money to fix up the house. Anything that's special about the loan should be noted, and then it protects the buyer in case it doesn't work out. In that case, in the FHA loan, the buyer could have walked away if needed. And sometimes it depends on what it is. Sometimes it could be just as simple as securing a railing, but sometimes it could be more. So it depends. So a realtor was handling a short sale negotiation and then turned over the file. It was completely approved by this point. The title then showed 3 sellers. And then once the inquiry was done, it was discovered that one of the short sale sellers had died and no probate had been done. So anytime you have anyone who passes away during or before a house gets sold, probate has to be done and completed to get tax clearance from the town or city. It's extremely important. No sale will happen unless probate clearance gets done. So the best thing would be to always confirm the names on the title and get signatures on the documents from all of them. And that would have alerted the agent, oh, wait a minute, I didn't get this one signature. Also turn over the file quickly to an attorney for them to begin assessing, or have someone help with the short sale for a second set of eyes. Okay. So buyer has to buy for insurance and pay for 1 year prior to closing. That is a mandatory requirement for any loan that a buyer is getting to purchase a property. Some banks and brokers have been allowing the premium to be paid at closing. So it comes up as at closing cost for the buyer. The insurance payment was sent out, but the paperwork wasn't provided till late, no PO box, it was sent out, and the insurance company didn't get it and canceled the policy, and a claim occurred. So the lesson learned would be, it's just much better to advise your client when they're looking for their insurance, just go ahead and pay the premium prior to closing. If the closing doesn't happen, they get their money back. There's no detriment to just going ahead and taking care of it, making sure it's all finalized rather than leaving it for the closing itself. So that is a good lesson. So wire fraud has really increased, and I mention it for you because wire fraud has also occurred to real estate brokers' accounts, email accounts, where it looks like it's coming from them. So the reason why I mention it is somehow an email was spoofed from a real estate attorney's assistant sending false wire instructions via email. And it was not clear, it's not clear exactly who had all the who had their email hacked. Could have been the real estate attorney, title company, realtor, or the buyers themselves. But what is clear is that the hackers had all this information in which to be able to act as if they were part of the transaction smoothly enough that the amount stolen, $307,000, was able to get taken. So it's very important. The lesson learned is that it's very important to verbally confirm wiring instructions. Always have your client confirm them. You're not going to be dealing with wiring that much, but just, let them know just as and if you get any wiring instructions, it looks like it comes from me, call me immediately. I wouldn't send anything, so don't believe it. And it has happened. It happened to a client of mine where their email was hacked. They had a Yahoo account, and the hacker pretended to be me and send them, oh, please wire to this instead. It only happened one time. And luckily the client did not do it and talked to me first. We have instructions and warnings on all of our documents that we do not change our wiring instructions. So, please don't do anything if you're told to wire it somewhere else without talking to us first. And always call the phone number that's in a source that and not what came in the email, because that could also be altered. And I've heard a lot of different attempts, and they're getting more sophisticated. So just be aware that it could be pretending to come from you, from your account. So just make your clients know, never wire anything without talking first. I love this updated kitchen. Seller's agent listed the kitchen as updated, and the buyer compared the listing agreement to the municipal town records to determine that work was done without a permit. And then they demand, now we need a permit for this work. Sorry, the lesson learned was missing there. But anyway, the basic lesson part is to make sure that you do have clarification from your clients. If they say, oh, this is brand new, this is brand new, this is brand new, did they get the work done with a permit? And some work doesn't need a permit. Some work does not need a permit. You're not sure. It's not up to you to figure out what does or doesn't, but it's just something to be careful about when constructing some descriptions. Okay. So this one is a two-part lesson with a dual agency story. So we start Act 1 with realtor and seller. The seller has a listing agreement set to expire in a few weeks. And the holdover clause in the listing contract, that clause that says that if after the expiration, the property sells within, and in here it was 60 days, then the seller would still owe a commission. Then seller the broker brought the seller an offer of 1.1 million from a buyer that they had, and the seller rejected that offer, and the listing agreement expired a few weeks after. Act 2, the realtor and buyer. So the buyer also has an agreement with the realtor that's still in effect. The buyer tries to terminate the agreement with claims of being unhappy, but the agency did not agree to terminate it, so it's still in effect. The agreement for the buyer, however, wasn't filled in properly. There were a lot of things missing. The name on the document matched the email of the buyer, the name on the email, but not the legal name. The buyer's signature was not dated, and the end date of the document had been changed. You could see whiteout that was evident on the original agreement, and it was not initialed. So it created confusion on who changed it and who agreed to change it. So here's the realtor who has these two different situations going on. And the final act, of course, the deception. The seller and buyer contract to sell and buy the property for 1.1 million, where the contract dated after seller's listing agreement expired and closed about 3 months later. The buyer's agreement was still in effect when they contracted this, so the realtor technically would have been able to get something from the buyer's agreement, except that the agreement failed based on the issues that I discussed earlier. So the buyer's agreement was no longer void by all those different reasons, and the realtor was unable to claim from that person. And the realtor is unable to get it from the seller because they closed after that holdover period clause. So that's a $55,000 commission. That ends the scene. And so that was a hard lesson, I'm sure, for that person. The holdover clause could have been 180 days instead of 60. Most likely, sellers and buyers aren't really going to do a deception that far out. So 60 days, people can wait 60 days, but to wait 180 days may be harder. And on the buyer side, make sure the legal name of the party is named in the contract. Also, again, to mention, make sure all the parties are named on the contract. So all the land records are, assessors' databases are available online, very easy to search to find out who's the legal owner of every property. And make sure you have the signature of every person on ownership. Make sure the document's dated. Contract agreements are good for 6 years. So it is the evidence that is based on when the statute of limitations expires. And any changes to the contract should be initialed. So rather than whiting out, the realtor should have just crossed it out and initialed it. So that was a tough lesson, I'm sure. Okay, so walkthrough issues. Clients go to the walkthrough prior to closing, and clients find a problem and want a credit. Now, due to TRID rules, TRID is something that is still in effect, but it's much quieter now. These were a whole bunch of rules that the federal government was putting in place several years back, and it was going to make everyone go crazy. I think a lot of real estate attorneys actually exited doing closings because of these upcoming TRID rules, where everything was going to be so tightened, on top, requirements galore. It was just very restrictive in a lot of ways. They've relaxed a lot now, so it's a lot easier to deal with this, but they are still legally in effect. So the clients found a problem and want a credit. And due to the TRID rules, if the buyers to get any money back, it has to be disclosed to the bank, even if it's that very second of the closing. So there are other options. First is obviously disclose the credit to the bank for approval. Do the walkthrough a day or two ahead of time, as long as the seller is out, of course, because if the seller is not out, you don't want to do any walkthrough until they are. But if they are, and then there's enough time for the bank to review and approve it, have seller do the repair, or buyer absorbs the issue. So those are some solutions that can help deal with any walkthrough issues that come up at closing or prior. So this one is the seller moved out early and thought they would save money by turning off the hot water heater prior to closing. Well, why pay for it, right? Well, the buyers went to do the walkthrough and discovered no hot water. The sellers remembered that they turned it off. It took a while to even really for the seller to kind of admit, oh, I turned it off, or everyone thought it was broken for a bit. Then the closing was held up while the seller turned it back on, and everyone had to wait some time to make sure that things were working. So luckily for the seller, there was no damage or anything that happened to the property during this time that they turned it off. But it really isn't a good idea for any seller to turn off systems or utilities prior to the day of closing. so that the buyers can test everything, but also so that there's no damage that happens in the property. Broken pipes is a big one that can happen when it gets cold. So like a day like tomorrow, hopefully everyone has their utilities, all your sellers have their utilities on and working and everything. So it's important that they are reminded to keep these things going, and then they can turn everything off the day after the closing. So this one is another walkthrough issue where a seller had a fancy California closet, custom drawers, part of the features. Sounds lovely. So lovely, I guess, that the seller took the drawers with her. She thought she had a use for them. So the problem was it's a custom closet. Therefore, anything that is attached to the property with the intention of kind of being a permanent fixture, even though it's removable in a sense, becomes a fixture. That custom closet became a fixture, so any parts of it have to stay. She had to bring back all the drawers. So you just want to make sure your seller knows that that fixtures can't be removed from the property, and if they have a question on what a fixture is or not, to ask, because it's important to make sure that the buyers don't bring up surprises and delay the closing. It's not worth it. It smells funny, so we'll deal with it later. So buyers went to walk through on day of closing and smelled gas. The agent told the buyer to let their attorney know when they go to sign mortgage papers. So the buyers went to the attorney's office. After they signed, they told the attorney, oh, by the way, there was the smell of gas. And then attorney learned that this was the only reported to her and not to the seller's agent or the gas company. And something serious could have happened at the house. Turned out there were actually several gas leaks, and it cost about $10,000 to repair. So, lesson learned is I'm just hoping that you know what the solution is. Should it happen to you, just call the gas company immediately. And let the buyer, the seller's agent know that there's an issue, but definitely call the gas company if you smell gas. But the lesson also for any other problem is that everything does need to be brought up prior to closing. So anything that is an issue or that the buyer has noticed should be brought up prior to closing, because if it happens after closing, it can become the buyer's problem, and that's it. And there's nothing that can be done. So rain, one of our favorite things, right? Sellers were selling a condo that was previously tenant occupied, and during the cleanup, the tenants vacated the property, and during the cleanup the weekend before, they discovered that the garage had some flooding due to a heavy rain, which hadn't happened before. So the management company was called and it was addressed. Sellers thought the issue was fixed and they did not relay it to the attorney or agent. And then the closing happens. And within a couple hours of closing, and seriously, this is the story I got, it really was within a couple hours of closing, a really heavy rainstorm came and flooded the garage again. Buyer calls the management company to take care of it. And the management company superintendent comes over to see the problem and says, oh, I thought we fixed this when it happened before. And the buyers threatened to sue the seller for non-disclosure. Non-disclosure is when your seller intentionally omits something of value or importance. It could be done on those real estate disclosure forms. It could happen there. It can happen, and in this lesson, it can happen after the disclosure and after the house's property is inspected and contracted for. So it's important to have the sellers disclose anything that happens to the property after the inspection, even if they take care of it. These sellers spent months in negotiations and finally paid $1,500 to avoid a lawsuit, plus whatever fees they had to pay for those negotiations. So it's just important, just in case that your seller is disclosing everything. Another example, which I don't have on here, is that I had a client who bought a house and closed, and about a month or two later, their basement flooded. And in talking to the neighbors said to my client, "Oh yeah, we always saw Bob with, the vacuums and things coming out of the basement and doing this and that. He always had problems." Well, going back to the disclosures, guess what it said when it talked about the basement and flooding? No, doesn't. So my client sued the seller in small claims and prevailed because he was able to prove that the seller intentionally didn't disclose the fact that there was a problem. Now, maybe he thought it was fixed or anything, but on the disclosures, it's important to have information more than not. Or my recommendation always is, don't even fill out those disclosures and pay the $500 penalty for it. It's just easier. And that way the seller doesn't have to worry about what was being said one way or the other. So that's the recommendation, is just not to do disclosures, but if they want to fill them out as properly as possible. So that way it helps protect them in the event something comes up after. So I am sure you have some stories and lessons that have come up over time. And if anyone wants to share any, otherwise I can talk about some other ones.
I don't have lessons, but I have a question actually.
Sure.
Okay, let me undo. Oops, sorry. I'm in a situation, so you say you would just tell the seller to, don't fill it out and pay the $500. I'm in a situation where they filled it out, but they filled it out, haphazardly. Some things empty, some pages signed, others not. And I'm kind of getting that attitude from the listing agent, like almost like he can't be bothered. Like, oh, they can just pay $500. But I'm just curious, from a buyer's perspective, you almost feel like if they're not going to fill it out and they just want to give you the $500, that they're kind of hiding something. So it's up to you to get the inspections done? Is like, what would you say in that instance?
So yes, that is the feeling that if someone doesn't fill out a disclosure, well, they must be hiding something. In New York, they barely fill out any disclosures. Everyone just pays the fee right away. But for some reason in Connecticut, it's gone mostly to the disclosure part. So I can understand that there's that feeling of, wait a minute, that doesn't sound good. It doesn't feel right. But the bottom line is, it really is the buyer beware. The buyer is responsible to do all their inspections possible in order to make sure that they're happy with the property itself. And if there's something that needs clarification or something that's really important, then it can be put in a contract or asked straight out. And the seller has to answer it if it's asked. They can't kind of lie. So maybe take the $500, maybe tell the listing agent, listen, these are not properly filled out. And sure, all right, so then pay the $500 if you're not going to do it. But your buyer should make sure to do their homework and their due diligence and make sure that they are prepared, because it is ultimately their responsibility.
Okay, so would you not recommend putting a contingency on, for the disclosures or for those items?
What do you mean, the contingency for the disclosures?
Like meaning if they wait and they don't get it now and they make an offer, just say contingent on getting these items. Like, if they ask for items and they're not getting it, the disclosure, I don't know, maybe they were asking to get a survey, or there's quite a couple of things and they got no information back. Were you saying you wouldn't?
So the disclosure, the statute says that they have to provide it by closing So you can't really put a contingency on it too much ahead of time. They have to provide it by them, but it's just habit that it's always provided with the contract just to make sure it's done. And a lot of realtors put them out at the time of their walkthrough showings as well. So sometimes you see them at open houses and things like that. So it is not necessarily a contingency you'd put in place, but more to know whether or not they're just going to pay the fee or not pay the fee. And then in terms of survey and those other documents, that is something that we do ask for in the contract. It is in there to say that the seller needs to turn over any surveys, manuals, appliance information, warranties, things like that, over to the buyer prior to closing. So those are the timeframes that you're going to get it. And if you don't, then at closing, they would owe you $500. And it would also, if they don't give the other things, as long as they're not purposely hiding anything, most buyers don't do anything about it.
Okay. Thank you.
But for sellers, as a seller's broker, you might want to start advising your clients, don't bother filling out the disclosures and just pay the $500. It's just, you know, less exposure to everything. Okay. Good luck.
Thank you.
Does anyone else have any questions? All right, so let me look up a couple of other stories that maybe have happened. So a standard contract was done, which is the fillable contract, and turned out that the buyer signed twice. So everyone thought it was the seller's signature and the buyer's signature, when it turns out it was just the buyer's signature twice. It was initialed by the seller everywhere, but wasn't signed. So those initials on the contract mean nothing in terms of having the contract be enforceable against the seller. So it's important just to make sure all the dates are filled in and fully done. That was a real life case. This one is a funny one. An initial deposit was made for the binder. And as a quick side note on the binder, as you know, KW doesn't accept the binder's payments anymore directly to them. So what it kind of has worked out better to be is to just give the whole deposit as of the time of the contract signing, whether it be the attorney version contracts, then we attorneys work with the client to do it, or to have it all due upon the real estate contract. And at that point, it could be given in whole. So that's some side note that I just wanted to mention. So the initial deposit was made, and then the buyers backed out. I'm sorry, they had an inspection that they put for informational purposes only, and they had a Hubbard Clause. If anyone doesn't know what a Hubbard Clause is the ability to make sure the house you currently own sells before you're obligated to buy the house you're contracted to buy. So the buyers ended up backing out under the informational purpose inspection and the Hubbard Clause. And the seller was so mad because she thought it was deception, that the inspection shouldn't have been an issue in any way because nothing major was wrong. And it was also supposed to be for informational purposes only. The problem is the Hubbard Clause as well. That allowed the buyer to back out. The informational purposes, what does that really mean? You know, it's a hard thing to necessarily define, and it allowed them to back out as well. I don't know if it would have allowed them to back out if they just relied on that, but it would have been an argument for sure. I don't know how it would have ended, but it's just, you know, when you're backing out, just be careful what reasons you're giving for the withdrawal. Another one was that a seller had to have an inspection of a furnace after the buyer's inspected it. The buyer's inspector questioned that there might be a crack. So the seller had to have the furnace inspected. The company came out and left a tag on the furnace saying that it failed and it is cracked. And the seller agent conveyed this to the buyer's agent by the phone, and credit was given. The closing was a month and a half later, and you know how memories are. The buyer and agent brought up the tag notice. The buyers and the agent brought up the tag notice and asked why it wasn't disclosed. They forgot they were told about the crack. And it was a lot of conversation between the two brokers when the broker offered the credit. So the lesson is always communicate anything credit, settlement, repairs, whatever the case may be, always communicate that in writing. And email is preferred to text. You can do text, but email in my world is much more preferred because you can see the chain of communication a lot easier. And the times, not, you know, the texts aren't always time stamped. So it is really a very important thing that the seller's agent could have quickly gone back to her email if it was captured there and said, hey, yeah, we discussed it, all done. You know, can't bring it up anymore. Instead, it became a big problem until everyone remembered what happened and it got resolved. Luckily, the agents were in the same office, so that helped because they knew each other. And she said, listen, I told you about this, but it would have just been resolved a lot quicker if it was all in writing. So the next thing is a deposit that was not made under the contract. So when it's a realtor's when it's an attorney's contract, we do collect the deposit and give it over to the seller's attorney. But on these real estate standard contracts, a lot of times it happens where the brokers are taking care of it, especially up in the different counties. The brokers take care of collecting the deposit and turning it over to wherever it needs to be turned over, or keep it, or whatever the case may be. But in this case, the deposit was not collected, and the deposit is consideration. This is a promise from the buyer that the buyer gives to the seller under the contract to say, we will buy it. And the seller's promise by accepting it is, we won't sell the house to anyone else. So when there's no consideration, there's no contract. And in this case, the seller used it as a reason to back out of the contract and take another offer. So you want to make sure that the deposits are on top, are done when they're supposed to be, that they've been paid, whatever the case may be. And the same thing is if the check bounces. So if, let's say the deposit was turned over, but then the check ultimately bounced, that is no consideration. And that can also be a problem as well. This was an interesting problem in that the buyer went to go get insurance for her new house during the contracted period to find out that 2 huge insurance claims were made in the year before selling the property. And these were not disclosed. On those disclosures, back to those things again, I'm telling you, they can be scary stuff. So, so the buyer said, well, wait a minute, what is all this? What's going on here? And they got the information. They had to assess at that time whether it is worthwhile to go forward. There was, some storm problems. That was what the answers were in the end. But it is best to, again, disclose as much as possible. The seller could have said on the disclosures, we did have water damage, but it has been fixed. The insurance company took care of it, whatever the case may be. It's just best to disclose as much as possible, because if the buyer finds out, it can give them a sense of distrust. if you cover something up. Another thing that happened was sometimes some buyers have a buyer has an opportunity when they're purchasing a property to buy an owner's title insurance policy, which is different than a homeowner's insurance policy. The title insurance policy takes care of any title problems that may occur for the life of the ownership of the property. And the title company would step in and act as the owner and take care of any problem that happens. So something that to happen is the buyer purchased the house and the seller's mortgage is paid off. And proof of that payment was done, but a release mortgage was never filed on the land records. And then it's discovered 8 years later that that's the case, and the bank is no longer operating, and now they don't know who to go to find out about the release of mortgage. Now, if the buyer had a title policy,
It's exactly what happened to me when I went to sell my house in New Jersey.
Oh,
we had probably had a mortgage with some small company, and they were no longer in existence, and they going through the, we were in Bergen County, the records, and couldn't find.
They're gone, right?
Yeah, and it was like, how does this happen? Like, and we had
now,
no idea.
Your title company, hopefully, did you have owner's policy?
You know what? I don't even remember, but yeah, it got taken care of. How, what, or where, I don't remember, but I remember for a short period of time, it was like exactly like just when everything's going smoothly. And I'm like, it was funny because it was like the mortgage that we had gotten with someone. We normally had these huge banks, and that was the other thing. It's like we were with like Chase Bank, and they didn't even know or discover it, and it was just discovered at the last minute. And we had some mortgage with some Joe Schmo company at one point for a small person that was like a friend of a friend or something, and they were no longer. But yeah, that was a little scary, I have to say.
Yeah. Well, I'm hoping that your owner's title policy kicked in and that the title company just took care of it at that point.
Yeah, that's what happened. Yeah, that's what it is, I think.
And so that's what some people opt because they think it's kind of a waste of money, but some people opt, I don't want an owner's policy. I make them sign something saying, well, I told you about this and that, and you've declined it. That's your prerogative. And very rarely do people do it, but it does happen. And you're just like, okay, because it covers a lot of situations that you don't even know. I had a client recently where they bought a house, and then 6 months later, someone sued them saying that you're blocking our easement to the property. And we're all looking at the title search. There's no easement. There's nothing. They may have thought they had something in place, but they sued them. And so the title company stepped in and took over, and now they're defending it all, and the client doesn't have to pay or do anything. And that was worth the extra $500 that he had to pay at closing. It's a one-time fee. So I'm glad it got resolved for you, though.
Muted, but you reminded me, like
I reminded you of that terror, right? Oh my goodness. I'm trying to think of what other. There are some, unfortunately, I think I've blocked out of my mind. So some lessons, some things that have happened and lessons learned. It's really funny because when I started putting these together, I'm like, I really had to ask a lot of people, because I'm like, I know in my 20+ years, I've had a lot of different things happen, but you truly block them out. Like they were just too traumatic to deal with in your mind. And so I just said, forget it. So I'm trying to remember things more.
Well, hopefully that's an indication that the majority of the time it's not like that. So
yeah, exactly. That it's so traumatic. Yes, I agree.
I have one. I don't know if anyone else has questions. I feel like I'm on, but I have. Am I on? I'm not on mute, am I? This thing.
No,
okay.
I hear you.
I have another question. Yeah, well, you were talking about the deposit, the earnest money deposit. So is that still? I mean, I know people say different percent. Is it still like people put down, the 10% and they do 9% and 1% as the? Is that what the earnest money? Because I'm new to this.
Yes, the earnest money, aka binder. aka deposit, 1% deposit. So those are all the same term.
Okay.
I'd have to say that really beginning with COVID, we all kind of moved away from that 1% in a sense and just did the whole 10% or whatever was agreed upon at the contract time. And that's just because I think we all wanted to just kind of lessen the amount of time of going back and forth dealing with something when you could take care of it all at once. So I would say that starting with COVID is when it kind of decreased in the importance of having the 1% obtained. A lot of people do is taking pictures of their check, but then giving the whole deposit at closing. The only problem that I will say that could come for the sellers is if they did have a claim to that 1%. It's a good faith deposit, which means that if the buyers don't act in good faith, you can keep that 1%. And
Gotcha.
then if it's not being given at this time and given when the contract and buyers backed out before the contract, then the sellers are out of luck. Now, did a lot of sellers keep the 1% good faith consideration? No, but it was a possibility. And an extreme example I could tell you where the seller would be entitled to keep the 1% would be if the buyer went and put out 7 offers just to see which one stuck. You can't do that. It's not good faith.
Gotcha.
Your good faith is, and so if the seller found that out, they could keep that 1%. And now, kind of with the shift that has happened, that 1% is not going to be available. So your sellers may be out of luck, if the buyers flake out. But the good news is they'll flake out quickly and they can move on.
So now I'm working with the buyer, and so the buyer if the buyer is making an offer now, they would, obviously I'm filling out the form, make their offer and put down 10% with the offer. And you're saying, but 9% and then keep a 1% of that in a separate check and give that to the attorney?
So the way I like it for when I'm a buyer's attorney is just to do the whole deposit at once, because it gets, annoying to get the 1%. And especially if it comes to me, I have to deposit, I have to wait for it to clear, then I have to write the check. So I like to get the whole deposit.
I guess I should ask the lawyer that, right? Like how they want it. Is that what it is? More so?
It's how also the offer, the realtor who you're making the offer may want it. They may want to see that 1%. So what we have done is have the buyer write out a 1% check, but it goes nowhere. They take a picture of it, send it to you. You send it to the other side and say, hey, here's our good faith deposit check copy. But then when the attorney works with the buyer for the next deposit, which will happen quickly, then we just say, did you, was that cash? Did you give it to anyone? No? Okay, let's give the whole thing right now at closing, at the contract, not closing, sorry, with the contract. So if your realtor is willing to accept just having the whole deposit given with the contract, that's the best way to go. But if they're really maybe old school and want that 1%, then you can do a check.
Okay.
And we just recently had one of the realtors, when she watches the replay, she'll laugh. So it'll be like, that's my story. But recently just had where she did turn over a 1% deposit to the other realtor. The realtor lost or just failed or something happened and never deposited. And we're closing next week. And the realtor is now panicking about this 1%. And it's like, you have to go get a bank check and bring it to me. And it has to be made payable to the seller's attorney. In the meantime, the seller's attorney and I are working together. And it's like, take care of it at closing. There's no, at this point in the game, there's no reason to go running around and getting the 1% and getting it delivered for a closing that's happening next week. It's silly. So.
Okay.
That's an old school, that's what he wants. He wants that 1%. But, I'm sorry their office didn't deposit it when it was supposed to happen. But right now we'll take care of it. Nothing's going to, be a problem. So, yeah. Does anyone else have any questions? Everything's running smoothly. I'm so happy to hear. Yay. So, yeah, it's been an interesting time for sure. There's definitely stories that still come up that are just amazing, and people can be amazing at times too, things they come up with to do or say. So yeah, if you think of anything after, feel free to give me send me an email. I will put my email in the chat for you. And or give me a call. I'll put that in as well. And yeah, so hopefully everything is all smooth and nothing really comes up. But you're welcome, everyone, and thank you for coming. It was a pleasure seeing you all and talking to you all, and hopefully it seems like a good market that's out there. I know inventory seems to be a little lacking, but things are happening for some people. So all right.
Thank you.
Oh, you're so welcome, and thanks for coming. And
Hi, attorney.
yes.
Yeah, sorry, Lisa Ginger Zhu.
Hi.
I just have few questions about the resale package.
Yes, sure.
And yeah, if my buyer is not satisfied with the resale package for not a very important information or questions, is that okay? Or any reason I just not satisfied, I don't need to provide why I'm not satisfied?
Yes. So the resale package, just for anyone who may or may not know, is a package that's required when a condominium is being sold and that the seller has to pay for it. And the seller has to get the resale package over to the buyers very quickly, because the buyers have a 5 business day period in which to review the package. And if they find anything that they don't like, they can back out for any reason at all. So Ginger, there's no reason, you don't have to give any reason or information. It is, we are not satisfied with the resale package. As long as it's done within the 5 business days, they'll be able to withdraw with no explanation. I actually know of a client of an attorney who withdrew under the resale package because they lost their job, but their mortgage contingency had already passed. Like they got approved for their loan and everything was all set, but then they lost their job. But the resale package was out there and still within the 5 business days, and they withdrew under that.
That's
yeah.
Nice. Okay, that's good to know. And also about the inspection, when you just mentioned if we have inspection essays for information only, then after inspection, for any reason, the seller or the buyer want to walk away. So we have to provide a reason. You said you need to be very careful to provide a reason why I want to walk away.
Yes. So for the inspection, I wouldn't use the general informational purposes only. Well, I guess as a buyer, you'd be fine using the words informational purposes only because it leaves more wiggle room for the buyer. It always depends on what side you're on, but on the seller, you'll want more specifics. Inspection for major mechanicals only. And in that way, if all the major mechanicals are fine and the buyers are trying to back out, they really can be held to, sorry, you can't back out under this. It's for me, you know, all the major mechanicals are fine. You're complaining about the steps, you know, the roof being on, you know, like needing to be replaced in 5 years. Sorry, that's not it. So that's the wording of how to put it in the offer or what to accept from the offer is important. And then in this case, these people had another out with the Hubbard Clause. So that was best for them to use both reasons. But if you're really trying to withdraw under the inspection and you don't have any other out, the seller could maybe hold you to that inspection if it depends, like the reason I explained before, like if you say one thing, but you're trying to get out of it for some other small problem or not related problem.
Okay, then if I put the clause there, inspection for information only, but the buyer reserves the right to cancel this offer on any findings in inspection. If I put this language there, can walk away for any reason, but whatever it's a, you know, it's a big problem or small problem, you can always find a small problem.
Right. So I think that if you can put in there that for informational purposes only, the buyer reserves the right to withdraw if any issue, you'd want to keep it more general. But on the seller side, as a seller's realtor, if you got that, you'll want to say, oh, wait a minute, not for any issue. We'll say for any major appliance issue or roof issue or something to that effect. And then that would dictate what the buyer could back out under or not. So if the buyer then wanted to back out for a major appliance issue, they can. But if they wanted to back out because, I don't know, the kitchen appliance, kitchen appliances aren't working, no, or something, or major structural, I don't know what I said before, but major structural aspect or major, hot water heater or something defect. But if they're trying to back out because the dishwasher doesn't work, that could be a problem. So
okay, so it's better just put the clause there to protect a buyer. Is you reserve the right to withdraw the offer for something like buyer we already talked to the buyer, so they understand what they can do, what they cannot do.
Right. So you'll want to keep it more general if you're representing the buyer of the reservation you're making. And then if as a seller's realtor, if you get an offer like that, you'll have to you should ask your buyer's agent to tighten up that inspection clause to make it only specific to certain things.
Okay, we got it. And I also had something like that last year. Is my listing, we signed a contract, a standard contract, and we received a deposit, a check. I gave the check to the seller's attorney, which is in Stanford too. And then later, the seller or the buyer, for any reason they wanted to walk away, it turned out the check wasn't deposited by the attorney. So the buyer did walk away. So in this case, the seller should have the right to pursue the deposit from the attorney.
Why did the buyer walk away? What was the reason?
The buyer walk away said they do not have enough funds, or for, I don't know if the right reason.
That they don't have enough funds. Well, then, well.
Yeah, but anyway, I think they just changed minds.
Yeah. That's kind of the 1% problem that I was mentioning. That's kind of going to start happening. I think that the shift in the last couple of years that's been happening with the 1% kind of being given with the contract. If the buyer backs out before that contract is even done, then it is almost that the seller's out of luck, and not going to get the 1%. Can they pursue it? Sure. They can do a small claim suit after the fact and pursue it.
Yeah,
if they
but
have a strong reason.
That's not an offer, that's a contract. It's a deposit. It's not 1% earnest money, it's a deposit.
And they signed a standard form contract, right?
Yes.
Was there a mortgage contingency?
No mortgage contingency.
Oh, and then they backed out and everyone signed the contract.
Yeah, and contract signed, it was a cash offer, and the buyer paid deposit, and we give the check to the seller's attorney. But for some reason, he didn't cash it. And when the buyer wanted to back out, and it turned out the check doesn't have money there. So
okay,
that has been for like at least like 1 month after the contract was signed.
Okay, well, based on that information, I think it sounds like the buyers would lose their deposit. I misunderstood. I thought you were talking about the binder. If you're talking about a cash deal where a standard real estate contract was signed, no contingencies, no inspection or mortgage or anything contingencies, and then the seller backs out, that seems clear that they should be able to do it. Now, unfortunately, the seller's attorney not depositing it is unfortunate. So what that means is that the sellers will have to go after the buyers in a court of law. You can do up to $5,000 or $6,000 in small claims. And if it's more than that, you have to go into the Superior Court, which is more expensive and more costlier and longer to do. But if it's under that, then they should go ahead and sue that, and they should have the seller's attorney, either help them with that in exchange for, not having this, done, or something to that effect. But yes, definitely, sounds to me like there's a default there.
Yeah. Okay. Thank you for your advices. It's
You're
very
welcome.
helpful. Yeah.
I don't know if you have more time, or just a quick question. What is the timing? And again, I'm fairly new. So what is the timing if you make an offer? And let's say there are some contingencies on there, but what is the timing of when normally the sellers would get back to you? Is there a time limit they have to get back to you? And, how many days do you have for your, to get the inspection? What is the legal, I guess, timeframes?
So there's no legal timeframes, but the
Okay.
inspection seems to be about 7 days in order to get the inspection and the results. And if you don't get them in time, then you would ask for an extension. For the mortgage itself, you would want to make sure with the mortgage broker what they advise. They may say 30 to 45 days in order to get an approval, and 45 to 60 days for closing. So if you're filling in dates, don't pick them on your own, ask the mortgage broker. I get sometimes some contracts where, they made the offer attractive, but put in really unrealistic times. And then all of a sudden now I have to be like, yeah, actually we need another month, and I need to change the date to this, and I need to change the date to that. And I can sometimes leave a bad taste in a seller's mouth. Now I understand sometimes you want to make your client look attractive, so there's a balancing act, but don't put in crazy dates that just are unattainable.
Luckily this is a cash deal, but which is good and bad, because then
Which
you
is
don't
even
have
better.
those. Yeah, it's good to go through, but then you try to find out, you want to speed it.
Yes. So the only thing for a cash deal, which I have one right now, just came about yesterday. We can probably close it in a week and a half, or less, but we just need the title search. That's the big thing. And that can take a week. And then a municipal search, which is searching the building department, zoning, wetlands, and all of those departments, that could take longer. Unfortunately, they're quite slow.
Actually, that's another question. I've gotten different things. I've gotten that lawyers, obviously do, but the lawyers get all that stuff. And then I have some agents saying, oh, you need to go and get this, and you need to go to town hall. What, as a beginning agent, what should I be doing? Should I be going to get those things or get any of that information? Or is it pretty much the lawyer, you're the one contacting town hall and all that? Or
ultimately, we order the title search to the municipal search, and we'll be ordering that. But in a discussion with my client, for instance, with the municipal search on this one property, he's going to be knocking the whole thing down and starting from scratch. So it really doesn't matter about getting a municipal search showing that there was a permit for a sun porch taken out 10 years ago. Or 8 years ago, because anything 9 years or older is deemed automatically closed. It's not worth it to do that, because he's going to have to get all new approval, permits and everything. So we're not going to do a municipal search for that one, and we can get the title search pretty quickly. Okay. But if your client wants a municipal search and wants to close quickly, then it might be prudent for you to go to the town hall to get it, because unfortunately they take a couple weeks for us, and it's crazy, and you might be able to get the info from there, or some general info to help them out, at least to make decisions.
And when do they lose their deposit? Like you said, they put a 10% deposit down. If they put a 10% deposit down initially, what time frame do they have before they lose that?
Just depends on their contingencies. So in
Okay.
Ginger's case, there are no contingencies. So the minute they back out and breach, then they're in default. And if they have a mortgage contingency and they back out within that time frame, they're not in default. So it really all depends on the way that the deal is constructed.
Okay.
Great. Anything
Thank
else?
you.
Yo, you're welcome. I love Adonis's godlike voice coming in. You there still?
Well, yeah, thank you for everything, Arianne. So I guess you guys all see the value of
Yes.
Attorney O'Donnell. So please tell your associate, tell all your friends about her, especially anyone that you have influence on that's newer to the business and might not have had the chance to make this meeting. So Arianne is awesome. Thank you for your time.
Oh, thank you. Thank you so much. I appreciate everything and the great
Thank you.
questions. And I look forward to, talking in the future.
Sounds
All right.
good. Thanks.
All right. Bye.
Thank you. Bye.
You're welcome. Bye-bye.